My name is Azizimani Gift. I'm going to be talking about a discussion on treaty disputes under the Vienna Convention for my public international law assignment. In this case, we're going to be talking about two fictitious nations known as State Aramika and State Bothuna. The introduction or the brief facts of this case are that the question we're tackling today explores a dispute between State Aramika and State Bothuna. The dispute is arising from a bilateral treaty established 10 years ago, and this treaty was to undertake a joint dam project, meaning that it was supposed to build a dam together and benefit from it together. State Aramika suspended the treaty, claiming failure to follow environmental safeguards, and State Bothuna in response denied these claims. She also asserts that the treaty is in violation of the fundamental international norms or jus cogens. So State Aramika claimed that there was failure to follow environmental safeguards, which made them unable to follow their obligations. This is what is known as suspension of the treaty. So they unilaterally suspended the treaty. We're going to be looking into the validity of this suspension, the legality of the suspension, and we're also going to be talking about State Bothuna's defenses, all while answering key questions along the way. We're going to start with the legality of unilateral suspension, which is where a big part of our discussion is going to be coming from. So in order to evaluate the validity of the unilateral statement or the unilateral suspension and the unilateral statement and the resultant suspension, we have to turn to relevant legal provisions. So we're going to be looking at the Vienna Convention of the Law on Treaties, the VCLT, which is a governing law on treaties, detailing the law on the formation. It also talks about the application, also talks about the interpretation, and even what to do in the event of a dispute over a treaty. So we're going to be talking about Article 26, Article 60, Article 53, Article 62, and Article 65. I'm going to be going in depth about each of these as we go on. So we're going to start with Article 26. We're going to be exploring whether the legality or whether the unilateral suspension of State Aramika of the treaty with State Bothuna is legal, and whether it is legal under the Vienna Convention. So Article 26 deals with Pacta sunt servanda. This means that parties to a treaty should act in good faith. State Aramika's suspension of the treaty without consent of the other party and without proper justification is in direct breach of the obligation under Article 6. So, as seen, State Aramika did not inform, did not seek consent, and did not give notice basically about the termination or the suspension of the treaty. And this is a violation under the Article 26, which talks about carrying out the treaties in good faith. We're also going to be talking about Article 60, which is material breach. Material breach is a violation of the term of the treaty that is so essential to the treaty's object and purpose, meaning that it's a violation of the term of the treaty that is so important that without it, the purpose or the point of the treaty is going to be off. It's not going to be there anymore. So suspension is only permitted in the event of a material breach, as seen in Article 60. State Aramika claimed that the failure to follow environmental safeguards amounted to material breach. So it's now up to State Aramika to provide evidence on this material breach, proving it violates a key provision and that breach is serious enough. It has to be serious and it has to be obvious enough for it to be a material breach. In my opinion, I don't think there was a material breach because there was no proof provided, and it would be very difficult to prove as it is given a very narrow scope in the law. So we're going to be talking about a case that touches both of those, Article 60 and Article 26. We're going to be talking about the Gabčíkovo-Nagymaros project case, which is between Hungary and Slovakia in 1997. So this case was very similar to our case whereby Hungary unilaterally suspended the treaty, abandoning its obligations, citing environmental concerns and a change in circumstances. It was held that clearly Hungary had acted in breach to Article 26 because it had not followed through by the obligation, and it had also not given consent or notice, just as State Aramica had not done. And for Article 60, Hungary claimed that there was a material breach when Slovakia implemented the plan to divert the river. Slovakia, in response, also claimed that there was a material breach, and because both of them were claiming, it was taken to the ICJ, and the ICJ decided that none of them actually amounted to material breach. Therefore, the suspension was not lawful under the VCLT. None of their actions was grave enough to amount to material breach. A very clear case of material breach is the Namibia Advisory Commission case, which took place in 1971. So we're going to move on quickly to the principle of acquiescence. So this principle is a principle in international law whereby a state is deemed to have impliedly accepted through silence or inaction on a certain matter. So in international law, even the silence of a country means something. That means you have to either accept or deny, because silence is going to be deemed as acceptance. Silence or inactivity is going to be deemed as acceptance. That's the principle of acquiescence. So it can be seen, the treaty was established for 10 years between Aramica and Bothuna. It can be seen that Aramica impliedly accepted the terms, or it can be deduced that it impliedly accepted the terms of the treaty the way they were. Because those 10 years of inactivity were a long time, and they could have brought a claim in any of those, but they did not. Meaning that it impliedly, or she impliedly affected or accepted the terms. A key case over here would be the Anglo-Norwegian fisheries case. It's a very common case, which this talks about the demarcation of borderlands, whereby the British asserted that they used the jagged system, while the Norwegians asserted that they use a straight line. So the ICJ held that it was a long-standing practice for it to be used as a straight line, which was in line with the principle of acquiescence. So moving on swiftly, we're going to be talking about Article 65. So Article 65 of the VVT or the VCTL, which is the Vienna Convention on the laws of the treaty. So it's the VCLT, on the law of treaties. It sets out the mandatory procedure to be followed when invoking grounds to terminate, suspend, or withdraw a treaty. So that's Article 65. It's the one that lets you know the procedures to take when suspending a treaty. So it says that the mandatory procedures include duty to give formal notice, which State Aramica did not do, stating the reason for the termination or the suspension, which State Aramica did not do, and giving due time for the other parties to respond. So all these reasons I'm giving you, all these reasons that I've said, are reasons why the legality of the unilateral suspension of State Aramica of the treaty are going to be in question, meaning that it's not going to be a lawful termination or a lawful suspension. So Article 65 also falls in this category because they were not able to follow the procedures taken, or the procedures taken to terminate the treaty. So this was also seen in the case of Colombia and Peru, the asylum case in 1950, where it was held that Colombia could not impose a unilateral statement without notice or proper justification. The Vienna Convention, we're going to be moving on to the Vienna Convention, the preamble at least, and along with Article 33 of the UN Charter, impose an obligation to uphold peaceful settlement obligations. This means that states are supposed to seek peaceful means of dispute resolutions. So according to Article 33 and the preamble, states are imposed, or states have a duty to seek peaceful ways of dispute resolutions. So Aramica breached this obligation by suspending the treaty without notice or consent, and this violates the peaceful obligation, and it violates international law and further renders the suspension of the treaty unlawful. So swiftly, we're going to be talking about the defenses of State Bothuna. So under State Bothuna denied the material breach claimed by State Aramika and also asserts that the treaty is inconsistent with the peremptory norms, making it invalid. So we're going to be talking about those peremptory norms and also talking about the defenses available to State Bothuna. Under Article 36 of the VCLT, the principle of rebus sic stantibus is established. So this is under Article 36. This rule states that there is if there's a significant unforeseen change in circumstances and those circumstances were essential to the treaty or essential to the purpose of the treaty, it can be terminated or suspended. Bothuna can assert that the climate change has caused a significant change in the environmental conditions, rendering the old treaty impractical, meaning that the old treaty is going to be impractical and that they were not going to be able to follow it according to how it was supposed to be earlier on. This was also seen in the case of Hungary and Slovakia, because this defense may be unlikely as Article 62 is applied narrowly, as seen in that case. State Bothuna claims that the treaty is incompatible with peremptory laws or jus cogens. So these are laws that supersede all other international laws. These are laws that cannot be overridden. These are laws that are non-derogatory, and they are found under Article 53 of the VCLT, which states that any treaty in conflict with the norms is void. This means that the treaty would be void or unlawful. In this case, the Treaty of State Aramika and Bothuna would be unlawful if it was found to be jus cogens or in contrast or in conflict with the norms. However, for Bothuna to prove this, she has to prove that the access to clean water is universally accepted and is a non-derogable and fundamental to international legal order. It is important to note that the resolutions are not binding and are merely persuasive. So this means that the argument is going to be merely persuasive but not solidified. So we're going to move on to the Lotus case. So the Lotus case between France and Turkey in 1927 gave way to the principle whereby states have the freedom to act unless there's an international law expressly permitting them not to. Under this principle, State Aramika can maintain that they had the right and the freedom to suspend the treaty, meaning that since there was no law, they could just have done it. However, this argument will be invalid in this case, as under the Vienna Convention, the suspension will still be illegal as they didn't give notice, and since this is illegal under the Vienna Convention, that means there is a law in international law that prevents them from doing so. We can see that Bothuna could also rely on customary international law or soft environmental laws, such as in 1992 the Rio Declaration of Environmental and Development the Rio Declaration on Environment and Development, which took place in 1992. We have the Paris Agreement. All these are persuasive and they influence state action. Such customary international law is not enforceable and is just merely persuasive. So it can be a way of persuading the courts to side with them. So lastly, I'm going to be continuing with the recommendations that I'm going to give State Bothuna and State Aramika. I'm going to invoke arbitration or the ICJ to resolve the dispute. So involving a party such as the ICJ or arbitration is going to be in compliance with Article 33 of the UN Charter and the preamble of the Vienna Convention. It's important that both of these solve the dispute without any threats or without any violence. So I'm also going to update the treaty to cater to modern environmental changes, following Article 62 of the VCLT, which allows for change in circumstances. The two parties should renegotiate, and come up with an updated treaty that encompasses all the modern environmental considerations. This means that both parties are going to be happy with the environmental considerations on both sides, since they're two separate states. And this includes the next treaty should also include the effects of the climate change and the rate at which it's happening. This will bolster relations between the two states, de-escalate the tensions, while also making sure that there's no possibility of conflict in the future. I'd also promote access to clean water as just Goggins. So as the Article 53 of the VCLT talks about just Goggins, Botswana should lead an initiative or start an initiative with State Aramika that recognizes access to clean water as a just Kogan norm. As of now, the UNGA has not recognized it as a human right, so that means there's still space for the law to change in the future, and I think State Aramika and State Botswana should push for this and make sure it's going to be a just Koggins, and also provides a law, provides another avenue for litigation and also for international law. I'm also going to establish a joint environmental monitoring commission. The aim of this commission will be to study and monitor the environmental impacts of the dam on both sides. This means that the states will be sharing information while also reducing the tensions and also reducing the environmental impact of having a dam. In conclusion, this case emphasizes the balance between the treaty commitments, environmental preservation, and the development of global standards. So, as seen above, Aramika's unilateral suspension is not legally justified under the Vienna Convention, and this is mainly because of the unverified material breach and the procedural shortcomings. Botswana's arguments are grounded in rebus sic stantibus and just Koggins principles which demand a higher legal evidence for it to be a substantiated claim. This case highlights an overarching necessity to update treaties in light of climate change and advancement in human rights. In future, nonviolent resolution, treaty updates, and worldwide promotion of environmental rights are ways that we can make sure that this conflict won't happen again. Thank you.